In my opinion, this case is controversial for a number of reasons. Firstly, of course, it was the British exercising jurisdiction or criminal jurisdiction over Australians. That is the background, I suppose. But the second reason it's controversial is that I think there are unquestionably fundamental flaws in the legal process that resulted in these convictions, and fundamental flaws in a serious criminal prosecution, albeit in the military context, are issues of concern then, and they remain issues of concern now. I think there is cause for such an inquiry, an independent inquiry as recommended by Geoffrey Robertson. I've focused in particular on those flaws in the process, the fact that the court of inquiry proceeded in some instances without the accused being in attendance, the fact that there was a complete denial of procedural fairness before the court-martial commenced, 1 day's notice, one defence counsel for 5 accused, that there were clearly fundamental failings in the court-martial process, and in particular the summing up on issues such as onus, legal issues such as provocation, other legal issues such as acting on orders. And then finally, and this perhaps is one area where unquestionably there needs to be an inquiry, is why these men who were accused and executed within, I think, 10 days of the decision were denied access to judicial review or an appeal, why additional time wasn't allowed, why it seems correspondence seeking such a review was interfered with, and why Kitchener and or his delegate wasn't available to receive that. What were the motives, in other words, for those who seemed, I think, on the evidence, to specifically shut down that option for the accused? And I'm still firmly of the view, particularly when there are people who volunteer to place themselves at risk and go necessarily into remote locations, issues regarding a flawed judicial process, albeit in the military context, are just as significant for them, and just as significant today, I think, as they were then. We need to look at what happened then, and not only insofar as redress is possible, but also in terms of ensuring that similar circumstances don't arise today. Well, this is unresolved business. Going back, I think it was considered by the Federal Parliament in 2004. The Federal Parliament would have been sitting in those days in Melbourne. But it's been unfinished business. It was certainly of real concern to the Australian Parliament then. It was of real concern to the Australian people. I think as a result of that concern, in fact, it was Whitten, I think, wasn't it, who was returned to Australia. In other words, implicitly, I think, in that occurring, recognising that things had gone astray and not been properly dealt with. We have never had an accounting in respect to those who were executed, and I think it's a legitimate matter that the Australian people are entitled to seek closure on, not simply those descendants of those who were executed. I think the fact that a man of the stature of Sir Isaac Isaacs, the Chief Justice of the High Court of Australia, being prepared to make representations on behalf of Whitten, which representations were successful, indicates two things. One, the issue was of substance, or if a man of that stature wouldn't have taken the action. Two, it was action that was supported by a very substantial portion of the Australian people. And three, and significantly, the representations were successful, implicitly indicating that there was recognitions there had been flaws in the process. From the British government's point of view, it was clearly a very, very difficult time in their history. And from all round, we will be inevitably looking at conduct that occurred over 100 years ago through our values of today. We're not seeking to be judgmental on the British government as it exists today, or the British people as they exist today, but the facts of the matter are there were fundamental flaws in the criminal process that resulted in these people being executed, and when that injustice occurs, I think it needs to be revisited, and certainly it is a matter of public interest that occur.